A mind-blowing motion was just filed in Kelsey Fitzsimmons case. So if you're not familiar, Kelsey Fitzsimmons is a North Andover police officer who was shot. She was shot by another fellow officer who was actually coming to essentially take away her baby. Now, the reason why he was coming to take away her baby is because Kelsey Fitzsimmons had a fiancé named Justin, and then the last name I'm always butchering, but Aylan or something, and they had a falling out. But they had a child together, so they're now fighting. They're embroiled in a custody battle, and they're in family court. And so he went and filled out this affidavit on his own, ex parte, which somehow you can do in Massachusetts. And just by him filling out this affidavit saying that she's a danger to herself and a danger to the baby, he was able to get the cops actually to take away her baby from her. So according to the cop who shot her, he claims that she actually, when they came to pick up the baby, take away her baby, she actually pointed a gun at him. Now, there's a lot of problems with the narratives here, and we're not going to jump too much into the weeds of that. That's not what this video is for. But that's what essentially the claim comes down to, that she was really trying to shoot him. So therefore, he just shot in response, kind of like self-defense. And therefore, she was shot in the chest. She went to the hospital for like 53 days. She was arraigned from her hospital bed. And initially, they tried to get a grand jury to indict her on attempted murder, but they were not able to do that. The grand jury no-billed that. And in fact, the only thing that they were able to indict her on is assault with a dangerous weapon. Okay, now, even if she'd be found guilty, she'd be eligible for 1 year of probation. So this is really already a losing proposition for the prosecution. They're not really getting what they want. But there's a lot more problems with this case. If you've been following the channel, if you haven't, then you can definitely go check out everything that's been happening in this case, including the whole issue with her probation being revoked. So there was her bail being revoked. There was a big problem with that. Also, eventually the judge was actually thrown off of this case now also because there's some alleged misconduct there. This is a real problem for the Commonwealth. This case just stinks. They should really just get rid of this case. But it doesn't look like they're doing that quite yet. And she does have a trial date coming up, I think in a couple of weeks, maybe even, or a couple months. So what's prompted by this motion? Well, Kelsey has this boyfriend or this fiance, which they have a child together, Justin. And as we've heard already from Justin, that he filled out this affidavit to take away her baby with, ex parte, and put in all types of things that she didn't have any sort of chance to rebut or contradict or disagree with, which is a problem in itself in Massachusetts. But, they're going to have to take care of that along with some other problems that they have. And now there's some evidence, apparently, that he perhaps, under probable cause standards, certainly, may have also committed some crimes. Now, remember, when you're looking at a motion that was filed in court, you always have to look at what are the attorneys asking for. That's what a motion is. You're asking the court to do something. So you can't lose the direction and the focus of the motion. Okay, so there's going to be a lot of pretty crazy allegations in this, and backed up with some pretty solid facts and evidence and attachments. But remember, the ultimate ask here is that they want the prosecution to produce any sort of promises or inducements or rewards that were given to potential witnesses in this case, and potential victims also in this case, Officer Nunan. So that's really what the focus of the motion is. So even though you're going to be hearing a lot about some other activity that perhaps Justin was engaged in, which seemed criminal, this is not a motion asking the judge to enforce his arrest or to affect his arrest. That's not what this motion is about. Now, some people could be screaming for that, and maybe they should take a quick look at this. And in fact, there was an email about an investigation into the potential crimes that Justin committed. But remember that this motion does not lose the focus here. The motion really is just for the prosecution to turn over any documents that have to do with rewards that the prosecution offered to Justin and Officer Nunan. So that's really the focus. But yes, as we're learning about this, it makes you scratch your head. Why is there no investigation into this case, into the alleged crimes, which some pretty strong evidence suggests, definitely on a probable cause standard, that perhaps there should be some sort of charges brought. So let's pull up the motion. We'll go through the motion. It's not too lengthy. We'll show you some of the exhibits, some of the surveillance, which is going to be very troubling. And then we'll leave it at that. So let's start. Here we go. Defendant's motion for disclosure of promises, rewards, and or inducements. Now, also remember that there's sometimes differences in jurisdictions. There are always requirements that the prosecution has to turn over. There's Brady material that they always have to turn over. But sometimes in different jurisdictions, you have to make specific requests for specific things. Even though it would fall under the umbrella of Brady and the prosecution should turn it over. But sometimes if you don't make a specific request for a certain Brady material, then, there's kind of wiggle room to get out of it. So here they're being very clear that they're making a specific request for this specific Brady material. So here we go. Now comes the defendant Kelsey Fitzsimmons buying through undersigned counsel and respectfully moves that the court order the Commonwealth to comply fully with Mass Rule Criminal Procedure 14 as amended. And that's Rule 14, which is just basically you got to turn over all the discovery and inquire. One of the jobs that Rule 14 requires you to do is that you have to inquire to see if there's any Brady material. Inquire throughout the prosecution team to secure disclosure of any and all promises, rewards, inducements, understandings, agreements, or benefits, formal or informal, made to or received by Justin Ilayan, I always butcher his last name, Officer Patrick McCarthy Nunan, or any other Commonwealth witness or potential witness in connection with this case. The defense requests specific written disclosure and written notice of its compliance efforts. This motion is grounded in the constitutional discovery guarantees and Triton and Brady, yada, yada, yada. Okay. The Commonwealth's obligation extends not merely to formal immunity agreements. Now, we are all familiar with immunity agreements. That is where the prosecution will offer an immunity agreement for one witness to testify against another witness. So they'll say, okay, we are going to, usually it's drafted, we'll draft up an immunity agreement. Anything that you say on the stand, we will not use against you. There's also sometimes transactional immunity, which means we're just going to completely not charge you with anything, regardless of what you say on the stand. We're just not going to be charging you at all. Anyway, different types of immunity agreements, but it's not limited. Brady material is not limited only to formal immunity agreements. It's for any sort of writings and inducements. So the prosecution can also have a wink and a nod at another witness and say, quietly, don't worry, we're not going to, if you have some problems, you have some criminal problems now, we need you to testify in this other case. You just don't worry about those other problems. Just take my word for it. So those are also types of promises and inducements and rewards, which also they're asking to be disclosed. And again, this is all Brady material, and this is a specific request for that. But to any promises of non-prosecution, unilateral forbearance from prosecution, offers of favorable treatment, even just favorable treatment, basically anything that you offer to another witness to get them to testify, they're asking for that to be disclosed, which is Brady material. Or request for such treatment that could reasonably affect a witness's credibility, bias, or motive to testify. A jury is entitled to know whether a witness avoided prosecution, received employment protection, financial benefit, or other favorable treatment in circumstances where criminal or disciplinary exposure existed. Here, the Commonwealth claims no such inducement exists. So the Commonwealth has made their position is that there's nothing here. There's no promises, inducements to anybody. No witnesses. We're not promising anything to. But there's a real problem with that. The circumstances and the weight of the evidence strongly points otherwise. The Commonwealth's blind eye is a purposeful, brazen tactical maneuver designed to avoid the total implosion of its case against Ms. Fitzsimmons, the true victim here. The court should enter orders to ensure that full disclosure is made. The defense makes a specific request for a discovery as to each of these referenced witnesses. So who's the first witness? Justin, the old fiancé, Justin Ilayan. And I'm sorry if I'm saying his name wrong. On July 3rd, 2025, while Ms. Fitzsimmons was hospitalized at Massachusetts General Hospital fighting for her life after being shot in the chest, at that time, as set forth on video surveillance, Justin Ilayan forcibly broke into her residence with 3 other accomplices. See video exhibit 1. Well, I bet you want to see the video, so let's take a look at that video, and then we'll come back to the actual motion. Well, maybe they're making this up, right? So let's see if there's actually some video. Well, what do you know? There is. Here's some video right now. Okay. This is Kelsey's house. Whoa. Yeah. Looks like he was trying to break in there. He's got his friends. That looks like a crime to me. Going through the house. We're going to see what he was doing in the house in a moment. Yeah, you got 3 friends there. Well, there you go. Well, now we don't have to see it again. But that is, excuse me, that's Exhibit 1 showing the surveillance from Kelsey Fitzsimmons' house on July 3rd when she's in the hospital. And there's Justin and his 3 buddies breaking in. So let's go back to the motion now. Lion had 4 days prior obtained a fraudulent ex parte family court restraining order from an affidavit full of lies about Ms. Fitzsimmons stealing full custody of their 4-month-old child and receiving an order that she stay away from him and the baby. That was the order we were talking about earlier. Apparently in Massachusetts, you can do this, which is just awful. In the affidavit, he swore that he lived with his parents in Stowe, Massachusetts. Given the order in his favor against Kelsey, his adversarial position in litigation against her, and her sole ownership and residence in the premises. So Kelsey owned that premises. He was not allowed in there. Lion had no residential or possessory rights whatsoever regarding Kelsey's secure locked property. He had no business going there and no legal right to enter. In fact, Ms. Fitzsimmons' father, an alarm and surveillance contractor, had just changed the locks and updated the surveillance system in the house after Lion's surprise litigation against his daughter. Well, it's a good thing he did, because they were able to catch that. As detailed in Ms. Fitzsimmons' sworn statement, so Ms. Kelsey also provided a sworn statement, and corroborated by Stephen Fitzsimmons, this is the following comes out. Lion broke the front door and door jammed to gain entry. He entered with 3 other individuals. The surveillance system and alarm were immediately disabled and destroyed, causing thousands of dollars in damage. The modem power was forcibly pulled out of its wiring. Lion stole cash, gift cards, Kelsey's passport, her personal laptop computer, and other valuables. Lion stole evidence contradicting his family court affidavit, a handwritten letter authored by Mr. Lion praising Ms. Fitzsimmons as an amazing mother. So you have a letter from Justin saying what amazing mother Kelsey is. And all of a sudden that letter is gone. Removed from the refrigerator to prevent its use, exposing his lies about her. Further, after stealing Ms. Fitzsimmons' laptop, Mr. Lion brought it to his parents' residence in Stowe, Massachusetts, where it connected to the Lion family's Stowe Wi-Fi network Braceland 4. So they're able to see that it connected to his parents' Wi-Fi. From there, he accessed her Facebook, AOL, and Gmail accounts, gained entry to bank accounts, withdrew approximately $5,000, closed accounts, accessed her medical records, accessed her pension beneficiary documents, and canceled her travel reservations, redirecting funds to his own accounts. See Exhibit 4. Well, take a look at Exhibit 4. This is Exhibit 4. Okay, this is the screenshot showing the history of what was done on July 3rd when she's in the hospital from her computer. Accessing her email, Facebook. Here's Facebook, AOL. Forgot password, Facebook. So resetting the Facebook apparently. And here we go. This is the Braceland 4 where it connected. So there you have Exhibit 4. So this is what he was doing on the computer by his parents' house. All these actions were traced and readily apparent on the laptop's recorded computer history. The laptop was returned to the home at some point in Kelsey's 53-day hospitalization. What had to have been another unlawful entry. I mean, returning the laptop is also an unlawful entry, an obvious effort to conceal the computer crimes. The conduct described constitutes probable cause for, at minimum, breaking and entering with intent to commit a felony, destruction or concealment of evidence, malicious destruction of property, unauthorized access to a computer system, identity fraud. These are pretty serious crimes. Despite requests for investigation. So there was the defense counsel's email. So Timothy Bradel sent an email to whoever it was, someone at the district attorney's office saying, hey, look, we got this guy. We got him caught on camera committing a very serious crimes, and the web history showing that he's committing more crimes. So, hey, you're looking for someone to arrest. This is the person to arrest. Sworn statements, corroboration, and video evidence. The Essex County District Attorney's Office has declined to charge Mr. Lion with any offense arising from the July 3rd, 2025 incident. Well, isn't that odd? Isn't that so odd when you have evidence presented on a silver platter to the district attorney's office that they're just going to turn a blind eye? Why? Why would they do that? Well, maybe there's some sort of agreement on the side. No agreements, emails, texts, or other writings have been provided relative to the non-prosecution. Further, requests that the matter be referred to an outside prosecutor due to the obvious conflict have been rebuffed. So then they said, look, you may feel that you're conflicted because on the one hand, you're prosecuting Kelsey Fitzsimmons, and now you're going to prosecute Justin, and he's going to be witness in her case, so maybe you can't have, okay, fine. So then appoint a special prosecutor. Ever heard of a special prosecutor before? Of course they have. So, but no, they chose not to do that either. This extraordinary leniency in a multiple felony case involving destruction of potential evidence in a pending criminal matter constitutes a considerable benefit. Whether characterized as prosecutorial discretion or declination, the practical effect is the same. Mr. Ayalayan avoided significant felony exposure. It strains credulity that there is no discoverable information surrounding this complete abdication of prosecutorial responsibility in favor of a witness adversarial to the defense. The Commonwealth must be ordered to provide or memorialize any verbal or written discussions, assurances, understandings, or implicit agreements or positions regarding the reasoning or cause of non-prosecution. A jury is entitled to know whether a key witness stands in a position of gratitude, vulnerability, or expectation of continued protection. All right, so that's with Justin. So they're just, again, remember, the focus of the motion is there's something else going on here. There's a reason why you're not pressing charges against him, and that's probably because there's some sort of agreement there, something. Whether it's a formal immunity agreement or not, it doesn't matter. We want it, and we deserve it, and we're entitled to it. Moving on. Officer Patrick McCarthy Nunan non-prosecution, employment protections, and financial benefits. Okay, now remember the victim in the case, according to the prosecution here, is Officer Nunan. Officer Patrick McCarthy Nunan shot Ms. Fitzsimmons in the chest on June 30th, 2025. The events are not recorded by police body cameras or residential security cameras. He claimed Ms. Fitzsimmons tried to shoot him. Without ever interviewing Ms. Fitzsimmons, the prosecution believed and adopted Nunan's fanciful, self-serving version of events. The Commonwealth sought to leverage the shocking allegation into an assault with intent to murder charge, which is a 20-year felony, which was rejected and no bill by a grand jury in favor of an entry-level Superior Court charge, assault by means of a dangerous weapon. In these circumstances, a 1-year probation disposition is eligible under the sentencing guidelines. The allegation that Ms. Fitzsimmons assaulted Nunan hangs by a thread, right? What's the evidence that they have? There's no cameras. There's no other police officers there. It's literally he said, she said. So the allegations that Ms. Fitzsimmons assaulted Nunan hangs by a thread held only by Nunan himself. As a result, the Commonwealth is strongly obliged to make him as comfortable as possible. If he's your star witness, then you want to make him comfortable. After shooting his colleague, he was immediately placed on critical incident leave from June 30th, 2025 through August 27th, 2025. So for him shooting somebody else, he was put on critical incident leave. Upon returning to work, Officer Nunan resumed full-time duties and worked paid details for approximately 138 days. This was the status quo. Now listen what happens. On or about January 11th, 2026, Officer Nunan failed to report for his scheduled shift and was deemed AWOL. Officers responded to his residence for a well-being check after phone calls went unanswered. Officer Nunan eventually answered the door and stated he had taken Flexerol and did not wake up for work. Despite this, he received only a written reprimand. He was placed back on critical incident leave effective January 17th, 2026. He has continued to be permitted to work paid detail assignments while on leave. Critical incident leave is ordinarily reserved for officers unable to perform duties due to trauma. Officers placed on critical incident leave are typically removed from active duty because they are not considered fit to perform the full responsibilities of a police officer. If you have to be on critical incident leave because of the trauma, well, then you probably shouldn't be on active duty. To defense counsel's knowledge, working paid details while on such leave is highly uncommon, if not unprecedented. In fact, the North Andover Police Department's collective bargaining agreement states a patrol officer on limited light duty shall not be eligible for details or overtime. The continuation of paid employment benefits following an AWOL incident raises serious questions regarding preferential treatment and whether employment protections are tied directly or indirectly to Officer Nunan's role in this prosecution. The details of these extraordinary arrangements are crucial to the defense. Paid leave, deferred discipline, employment protection, or internal agreements regarding discipline are tangible benefits. If any favorable treatment was extended in connection with his cooperation or testimony, it is impeachment evidence that must be disclosed. legal standard. Okay, we know you got to turn over all this information, and therefore this is a request for relief. They want to see if there's any sort of agreements basically out there. All right, so that is the mind-blowing motion that we just hit the docket today. And watching that surveillance footage of somebody breaking into Kelsey's house, who we seem to suggest, according to the defense, that it's Justin, definitely looks like breaking and entering to me, and burglarizing and stealing her stuff and then accessing her accounts and banking information and all that stuff. So seems like there's a real problem there. Real problem. So the case just keep getting worse and worse and worse and worse. In case you think it's not bad enough, it just keeps getting worse. So that is the update on Kelsey Fitzsimmons. So if you haven't yet at this point, please like and subscribe. And we are, of course, going to be following this case as it gets closer to trial. Hopefully they will live stream the trial. If it gets to trial, they should just drop the case probably. So if they take my advice, so just drop it and move on from this case. All right. So that is going to be it. Again, if you haven't, please subscribe, please like, and we will see you next time.